Major breaking news out of the United States District Court for the state of Florida. A Judge Catherine Kimball Mizell, has declared that it is unconstitutional under the Second Amendment for the federal government to ban guns in post offices, at post offices. We're going to talk all about this and break down the judge's opinion in 1 second. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say a top 5 finalist in 2 separate categories for the 2024 Gundy Awards, one for top male influencer in the United States in the Second Amendment space, and the second for the top voice of the Second Amendment movement in the United States. I'm proud to be nominated and a finalist in both categories. All right, folks, a few days ago, Judge Catherine Kimball Mizell of the Middle District of Florida has issued a very important Second Amendment ruling on quote-unquote sensitive places. As you know, sensitive places is a euphemism for government-mandated gun-free zones. In the case of the United States versus Emmanuel Ayala, I think I'm pronouncing this, I think it's Ayala, Ayala. In this case, a postal worker was indicted for having a firearm, a regular handgun, I believe, at the post office, and he was indicted under federal gun control statute 18 U.S.C. 930A on the grounds that he had a gun at a post office, and this was allegedly a no-go. The defense attorneys filed a motion to dismiss the indictment on the grounds that the federal statute violated the Second Amendment's right to keep and bear arms under the standard of Heller and Bruin. I'm happy to report that Judge Mizell has held that the government, the United States government, the Department of Justice under Joe Biden and Merrick Garland has failed to meet its burden under the Bruin test to show a historical tradition of carry restrictions in United States post offices, and therefore dismiss the charge. Just to jog your memory, under the Heller/Bruin test, once the text of the Second Amendment is implicated by a gun control statute today in the 21st century, the burden shifts to the government to justify it on historical grounds. The presumption is that if the text is implicated, the presumption is that the law is unconstitutional under the Second Amendment. Obviously, the text of the Second Amendment reads, "The right of the people to keep and bear arms shall not be infringed," preventing an American citizen who is part of the people from being able to bear, which means to carry, a handgun on federal property. Obviously implicates the right of the people to keep and bear arms because you're banning a member of the people from being able to bear, i.e. carry guns in a particular place. So the text is implicated, the burden shifts to the government, as the law is presumptively unconstitutional, 18 U.S.C. 930A. And then what happens is the government can come forth with historical analog laws. They have to be actual laws from the time of our founding in 1791, whether it be common law, whether it be state statutes, whether it be state constitutional rights or state constitutional powers, whatever, or the federal constitution, whatever, but some actual law enforceable. It cannot be airy-fairy history of some historian from Harvard saying, hey, here's my view of history in the 18th century. No, the burden is on the government. Come forth and say, here is a law that was on the books. And this law was ubiquitous. It was well established in a long-standing tradition in the United States from the 18th century through the 21st to justify that restriction on Second Amendment rights, if you will. Now, I'm happy to report that the judge specifically said that there's no way the government could possibly meet this burden, and we'll get into those defenses in 1 second. But before I get into the specific arguments that the government raised and why they were rejected, and rightly so, and then I will give you a couple thoughts about how I think that the opinion could have been improved upon by this very prominent young judge. What I want to say before, first and foremost, is to answer one question I've already seen quite a bit on X or Twitter, and that is, what does this law mean for other people in the state of Florida and across the country that go to the post office? The answer is, this decision right now only applies to the specific criminal defendant, Emmanuel Ayala, in this case, because he was indicted and he moved to dismiss the indictment, and that indictment has been dismissed. So it applies to him, but this is different. This is a criminal case that only is dealing with his rights and his situation, his freedoms. It is not like a civil case where, let's say, the Second Amendment Foundation, the National Association of Gun Rights, the Firearms Policy Coalition, the NRA, brings a lawsuit, civil lawsuit, to challenge a gun control regulation on the grounds to get it enjoined with a permanent injunction, as declared unconstitutional under the Second Amendment. So therefore, there is no injunction in place in the federal system, or even in Florida for that matter, saying that this law is unconstitutional. So what the government argued in this case was the same sorts of things they've argued in other quote-unquote sensitive places cases. The federal government specifically stood up and said, well, the first thing is the Supreme Court has already defined that government properties are sensitive places in the dicta of Section 3 of the United States Supreme Court's decision in the District of Columbia versus Heller in 2008. That is exactly what they tried to argue, but Judge Mizell specifically rejected this and said, look, Heller's language about certain sensitive places, including government buildings, is simply dicta. Now, as you know from this channel, dicta is different than the court's holding. A court holding of a court's opinion, specifically the court's holding found in the opinion, is the actual decision, the specific narrow decision. So, for example, the holding in the Heller decision is that the United States cannot ban handguns under the Second Amendment. That is a holding. The holding in the Bruin case in 2022 is that a may issue permitting regimes given discretion to government agents to determine whether or not someone needs to exercise their right to carry guns in public is unconstitutional under the Second Amendment. The rest of the language in those opinions is explanatory, sometimes referred to as dicta, or setting forth the reason of the decision. But again, the central holding is not the same as dicta. The reason why this is so important is there was a passing reference in the Heller case that simply says that, nothing about the Heller decision, which is whether or not handguns could be banned by the District of Columbia, is implicating or affecting, long-standing, or what they said is, laws associated with gun bans in schools or government buildings like that. They said we're just not getting to it in the Heller case because we don't need to. And that's all it was. It was dicta. It's not binding on other courts and so on. So bottom line is what Judge Mizell said is this. Look, that is not binding on me. That is simply dicta. I have no duty to follow that language in Heller for several reasons. First of all, in the Bruin case, they narrowed the scope of what they viewed to be quote-unquote sensitive places to simply 3 places. That would be legislative assembly halls or chambers like, the Capitol or state houses, courthouses, and polling places. And she said specifically that the Heller airy-fairy language, just kind of talking generally about government buildings and schools, does not prevent me or does not allow me to avoid doing the actual historical analysis as to whether or not a post office is a sensitive place, also a place that, i.e., a place the government can mandate no guns are allowed. She then went on to say that, as Bruin noted, there were relatively few laws restricting carry, and they were really just limited to, again, legislative assembly halls, legislative chambers, 2 courthouses, and 2 polling places. Then she went on to say that bear in mind that there were postal offices, there were mail delivery at the time of the founding, and none of them whatsoever had anything to do with restricting firearm ownership in or around these places. So again, she points out that the Supreme Court said that if there's a societal problem that existed in the 18th century in 1791 when the Second Amendment was adopted that is similar to the societal problem today, and our founding fathers decide to address that societal problem with some law or means other than gun control, then that basically proves that the modern day gun control laws are unconstitutional. Then she goes on to say at the time of the founding, there were indeed mail delivery services. And there was, of course, concern about the mail deliverers being intimidated or attacked. There was concern about, the mail, all these sorts of things. And the one thing that the Founding Fathers did at the time of the Second Amendment and the founding was they did not ban guns. They tried to address it in other ways, but they never did it by banning guns. This makes a lot of sense for several reasons. One of which, of course, these are the same exact men that adopted the right of the people to keep and bear arms. So it would be odd that at the same time you have a group of people that believe it's a fundamental right to keep and bear arms all across society. They would be at the state and local levels passing gun control laws all over the place. So that doesn't make sense. Moreover, to the extent the anti-gunners in this case, the United States was trying to use late 19th century historical analogs, it's simply impossible to do so There's no argument whatsoever to even consider that, because keep in mind, this was a lawsuit against the federal government, and there is no debate that at the time of 1791, when the Second Amendment was adopted, that only applied to the federal government. So certainly you just have to look to federal laws, and there's no federal laws restricting guns in and around the mail delivery service at the time of the founding, or frankly for any point in time, as I recall, until sometime in the 20th century, I believe. I think if I could offer up one suggestion to improve this case or improve this opinion, is that I think that the court did not quite get the analysis right about why guns can potentially be banned or were banned in, again, polling places, legislative assemblies, and courthouses. She talks about intimidation and some other general concerns, but if you look carefully at the unique characteristic that brings together what is the common underlying theme or fact on the ground at the time of our founding that made courthouses, legislative assemblies, and polling places sort of what was the common thing that allowed them to restrict guns in those places. And I think the right historical answer, and this is the right answer for a whole host of other reasons, is that they provided armed security at these places. They also provided a single point of entry, limited points of entry, which means that there's only one way in or one way out of these legislative assemblies, courthouses, and the polling places. You couldn't just sort of walk in wherever you wanted, like let's say a park. So you have this sort of limited number of entry points. And you had armed security. In the context of courthouses, you had armed bailiffs. In the context of legislative assemblies, you had sergeant at arms. In the context of polling places at the time of the founding, remember, we're not talking about today, we're talking about the time of the founding in the 18th century. At polling places, you had armed sheriffs and their deputies, and you had limited places for ingress and egress. You couldn't just wander in, like I said, in Central Park. There's countless entries into a Central Park and other parks. So again, this is why I think the right reason why those places can be deemed gun-free zones, government-mandated gun-free zones, or sensitive places, is because the government treated them as such. And the way the government treated these places as sensitive places in 1791, what made them unique is that the government provided on its own dime guns and limited entry points. That's what makes these sensitive places. There's no sort of airy-fairy history about, oh, it's a core government function, or there's worry about intimidation, or people are scared, or there's vulnerable people. No. What makes these three things at the time of the founding sensitive places is, again, armed security provided by the government and limited entry and egress. Ingress and egress, entry points, that's what made them sensitive places. And if those don't exist today, like TSA in the modern world, they cannot be deemed sensitive. You should not be able to be banned from bringing your gun there, because if the government is not going to provide comprehensive security, take on the civil liability of getting sued if something bad goes wrong with it, and they don't provide armed security, it is not a sensitive place. They are not acting as a sensitive place. They're not behaving like it's a sensitive place. It's not a sensitive place, and you should not be able to be barred from bringing guns into those places. What the government did to try to save the face, to save the statute, is they said, we need to bring forth historical experts and other experts, and then we need to have an evidentiary hearing. And I'm happy to report that Judge Mizell specifically says, you guys are no way, no how, nada, you're wrong. Specifically, here is what she writes, and she's absolutely correct here. She says, quote, the relevant inquiries are interpretive. The relative inquiries are interpretive, and that the questions at bottom are legal. Legal, not factual, legal. Nothing differs about constitutional cases. The United States Supreme Court did not require expert testimony to determine the original meaning of the Confrontation Clause in Crawford or the vesting clause of Article 2 in Celia law. After all, it is the judicial function, the judge's duty, it is the judicial function, not that of an expert witness, to say what the law is, citing Marbury versus Matterson. Now, this is 100% right, because as we've talked about before, just think about this from a common sense point of view. How many experts were used in the Second Amendment case of Heller? 0. How many experts were used in the Second Amendment case of McDonald? 0. How many experts were used in the Supreme Court case of Caetano versus Massachusetts dealing with the Second Amendment? 0. And how many experts and testifying experts were used in the United States Supreme Court case involving the Second Amendment called Nyserpa versus Bruin? You got it. 0. So you guys out there in the Second Amendment movement, do not use experts. You are playing a sucker's game. We will get into this more in a future video, but I'm telling you right now, going forward, I'm going to start being more firm on this. Do not use experts. You are playing a sucker's game. You're playing into the anti-gunners' hands. You don't need them. If the Supreme Court doesn't need them in their Second Amendment jurisprudence to interpret the Second Amendment, you don't either. And Judge Mizell, right here in this case, in Florida, 100% agrees with me and explains why I am right. Because I'm not just right. The Supreme Court doesn't need it and has never needed it when it comes to interpreting any part of the Constitution because these are legal questions and not factual. And since they're legal questions, you do what legal experts do, which is called a judge and lawyers. The lawyers find the law, they find the historical laws, which is what the Bruin case calls for, and then the judges interpret those historical laws. There's no need for experts because the judge is the expert and the lawyers are the experts. So stop. And Judge Mizell proves my point. The last point I want to make, and this is important, I'm giving you a heads up. If there is ever another Republican president, and let us hope and pray that there is soon, Judge Mizell is certainly a rising star. This is a woman who is just, I believe, 33, 34 years of age. She is an originalist, undeniably so. She is a former clerk to Judge Greg Katsas on the United States Court of Appeals for the D.C. Circuit, who is viewed as a future Supreme Court pick. And she is a former law clerk to one Justice Clarence Thomas. So she is well trained and understands the importance of originalism, which is, originalism means we interpret the Constitution as it is written and as it was understood by the original public understanding at the time it was written, not some living constitution made up by some professor in the 21st century because they don't like the we the people decisions, so they try to get their results that they want in the courts using unelected politicians wearing black robes. No, that is not what originalists believe. They try to interpret the law as it's given to them by the U.S. Constitution, as it was understood at the time of the founding, because again, when you enter into a contract, the words and the meaning and the understanding of the people that entered into the contract at the time they entered into the contract is what's binding. And since the social contract, which is the U.S. Constitution in a sense, was entered into in the late 18th century, that's why we laser focus on the meaning of that document and as it was understood by the public and the people that wrote it in the late 18th century. So again, keep your eye on Judge Mizell, who is a young rising star in the originalist movement. And again, she's also well known because I believe she's the one that struck down as unconstitutional Joe Biden's COVID-19 mask mandate on airplanes and public transportation back in the era of COVID. So keep your eye on Judge Mizell. I think she has a bright future, assuming there is not an unlimited supply of Democratic presidents for the rest of our lives. But only time will tell us how that all plays out. So there you have it. I hope you learned something here today. The Four Boxes Diner. I'm sorry it's a little late. I've been doing some research over the weekend, but we finally got to this topic. And again, we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.